morning and welcome to the Court of Appeals. Today, we have two matters on our calendar in which we will hear oral argument. Is it Mr. McGinnis?
Yes, Your Honor.
Have you been to the Court of Appeals before?
Not really.
Well, welcome. And the way that the clock works, I think you probably know this, but the way the clock works is that it counts down from 15. It appears that you've reserved 4 minutes for rebuttal.
Yes, Your Honor.
Once you get to the 00s, then you'll be into your rebuttal time, and we'll try and help you keep track of that. But that's what the clock will tell you, and then it may be time to sit down. If you could please enter your appearance when you take the podium. Each time you take the podium, that will help our listeners, all thousands of them, out in the community that listen to these because we live stream these arguments. Please speak into the microphone and try not to move away from the podium too much. That will help record your voice as well. And if you're ready to proceed, please do so. And this is the case of In re M.K.
May it please the court, good morning. I'm Attorney Michael McGinnis, counsel for the appellant, Mr. Keogh. I'm here on an appeal from termination of my client's parental rights from the First District Court. I'm here to argue to the court that my client has a fundamental right protected by not only the United States Constitution but also the Utah Constitution to sustain his relationship with his child. And it's his fundamental liberty and interest to care and have custody of his child. I'm going to make a bold statement here today that I believe that we wouldn't be here before the court if Mr. Keogh would had a different economic standing. I believe Mr. Keogh did everything he could in his power to comply with the terms and requirements of the lower court during the service plan. But because of his financial hardships, he was not able to do that.
And that's certainly a tough circumstance, although it appears from the record as though he did not take advantage of every opportunity that was available to him, even in California, and did things like not participate as fully as he might in Skype or whatever it was. And I realize that would be difficult with children who are under a certain age. It's not as though they're going to sit and have a conversation with you. So I think that these are really tough circumstances, but even if we agree with you about the legal importance of the parental bond with children, isn't there some limit in a circumstance like this where parents and children are separated by a couple of states and the economic circumstances are unfortunate?
Your Honor, I think you're correct. However, I think there's some factors that I like to highlight that I think are important to point out in the record. First off is the fact that the beginning of the services, or the beginning of the case, Mr. Keogh there's no findings against Mr. Keogh. Mr. Keogh submitted himself to the jurisdiction of the court with the understanding that the division will help him pay for these services. At the time, Mr. Keogh was not on disability. He had no job. He was living on state assistance for housing, food, and even his cell phone. So because of that, Mr. Keogh had the impression that the state of Utah would help him. And as time went on, and after, I believe the caseworker made requests to the division for funding. Those requests were denied.
So what do we do about the fact that it appears that your client stipulated that the reunification order was adequate?
Your Honor,
The services, that is.
I hope I didn't interrupt the court.
No, it's all right.
Your Honor, I think that's an important argument that the opposing counsel has made.
Which, as far as I can tell, is unrebutted because I don't think you filed a reply brief.
I did not, Your Honor.
So we have that out there, and we've looked at the record. How do you respond to that?
Yes, I think there's an error in the trial court's finding of facts, which I think the opposing counsel that's where they got that argument. In the court's findings of fact at the conclusion of the case, they refer to October 24th of a hearing. If you go to my addendum C in my brief, it talks about the permanency. The actual title of the document is Permanency and Hearing Findings, Conclusions, and Order. And, Your Honor, I did make some stipulations, but here's where the error is. The two stipulations I made were first, that I stipulated to combining permanency and the termination trial in one hearing. Second stipulation I made was the fact that I would allow the Attorney General's office to proffer evidence on the record, meaning that she didn't have to call witnesses. But I did not stipulate to any findings that the division made reasonable efforts.
So did you challenge the trial court's finding?
If you look at the actual findings, it never says that the finding from the October 24th hearing, that document says what I just said. It says that there was proffered evidence made on the record, and that's what the court used to make its findings. Where the error comes from is the findings and facts and conclusion of law from the final order after the termination of the trial.
Right, and did you challenge those?
I did not realize the error until it was pointed out to opposing counsel in their brief that there was a stipulation. I never saw that there was a stipulation at any time during my handling of the case.
Okay.
So the court ordered that reunification services be terminated, but you didn't stipulate that the services that had been provided to Mr. Keogh were appropriate and
That's correct.
satisfactory.
I think if you look my brief at Denim C, that document, that's the document from that hearing, and that's what covers that. And you know that's a big part of my argument is that there weren't reasonable efforts made by the city.
Sorry.
Go ahead, Your Honor.
I have a question about one thing that troubles me about this case is the fact that the child appeared to suffer from some significant neglect the first part of its life. And there doesn't seem to be, I can't find really anywhere in the record that suggests that either parent were fully aware of the delays and the disabilities and the true struggles that this child is going to have, and the specific care and therapy that the child will require growing up. How do you address that? And I guess it's kind of a factual issue, but how do you address that?
First off, I think the court's correct on the record. I think that was testimony that was brought out at the hearing. First, my argument to the court is the fact that children have developmental issues in every type of home there is. What I'm arguing, I don't think that there was every proof or correlation to the way Mr. Keogh or the mother was raising the child. I think that I recall even asking a question from one of the doctors that it could have been just a genetic issue. So, second of all,
I'm sorry. Let me just ask a question on that. Isn't there evidence to support the court's finding that it was due to the care of the child, where the testimony was that the child made, advanced leaps and bounds once the child was in the care of the foster mother? Isn't that sufficient to support an inference that the developmental delays were in fact due to the parenting prior to being in DCFS custody?
I think what I would have to say to that, yes, your reporters are also correct that there were significant progress, but at the same time, when the child was taken to Utah, the child was 2 years old, and then at the time of the hearing, I believe he was 3 or 4, and we don't know if those progresses or those leaps would have been made if they were in Mr. Keogh's custody as well. I think I mean, I have kids, raising kids develop all different areas, different times, and sometimes kids make leaps and bounds on their own as they grow. Mr. Keel was the primary caretaker of the child from the moment he was born to he left. He testified that, and the mother also testified that Mr. Keel was the one that got up in the morning with the child, fed the child, all those types of things. And as I'm running out of time here, I'd like to point to the argument of the strictly necessary part of this. Now, opposing counsel argued that I didn't file a motion in this matter about that issue. I can tell you that it was brought up at trial in my opening and my closing, that the issue was preserved, that it was argued to the court that there should be something other than termination of parental rights. I think this is a perfect case for something other than that because it's a family placement. I think that it would have been easy to have some type of guardianship in place where the child could have stayed in the foster mother's care and Mr. Keogh could have retained his parental rights and have that bond with him. I think it's important, and I also think it's in the best interest of the child to know who their father is and to have a relationship with him.
Mr. McInnes, how is that realistically going to work with a parent who lives 2 states away and really lacks means? Again, it's for some of the reasons that this appears to have failed, that is going to be a reason why that relationship is going to be difficult to sustain. Wouldn't you agree?
I would agree that it would be difficult when the child is younger. I think as the child got older, and then as Mr. Keogh was able to get more resources, I mean, he just barely got on disability before the case ended. So he had more funds to get into treatment and to travel. I think that he was willing to make those sacrifices and do that.
Was there any testimony? I realize that the foster mother was a maternal relative. Was there any evidence that the foster parents would be open to a permanent guardianship arrangement rather than adoption?
The only testimony that I could recall from the record was from Miss the mother, saying that there was something that she wanted to arrange like that with the foster mother. I don't believe the foster mother had made any statements about that.
But I do recall from the judge's order, but correct me if I'm wrong, that the foster mother did say that she was open to arranging for visitation from the father if that was appropriate for the child. Is that right?
I believe that's right, yes, Your Honor. And that's something that I support, and I think that would be the ideal situation. Thank you, Your Honor.
Thank you, Mr. McInnes.
May it please the court, Martha Pierce, attorney guardian ad litem for the minor child. One issue is whether or not father's parenting caused the child's problems, but the more immediate issue was father's ability to address those, and the caseworker had made it clear that he needed to be in town and interact with the child to learn how to address the child's problems. This is a child that you can't do long-distance parenting. And even though father was short on funds, poverty was not the issue. The division would pay for him to come out here. And I think it just should...
No, as I understood it, the division would pay for him to have overnight lodging.
Right.
They weren't going to pay for him to have transportation.
They weren't going to pay for... That could be true. But he had no interest in moving. And that was his choice. He wasn't incarcerated. He wasn't deployed. He had a choice, and he knew his child was in trouble. Whenever the state's involved, you know your child's in trouble. And so I think that speaks volumes about his disinterest in this child, that he didn't make the effort to come out here. And at trial, he was asked, well, was it a big effort for you to come out here for trial? His answer was no.
And he wasn't employed either. When you mentioned the moving to Utah, that's something that hadn't occurred to me. Was there any information on why the father was in California or why relocation wasn't feasible?
He said some things that sounded more to me like excuses. I was worried about my housing. I really didn't want to. He had a number of things, but I think any other parent, if you know your child's in trouble, if you know your child is elsewhere, you go out there. There's a lot of long-distance parents, but they usually have a hands-on parent. But some people don't have the luxury of that. And if that's the case, then you don't parent by long distance. This is a child that needed to be there. And there was ample testimony about, and the letter from the therapist, I think, also explains why this child needed needed immediate parenting, not just long-distance parenting. And there was, mother provided testimony that the father had done something to the child to put bruises on his cheeks. So there is some evidence of father being violent with the child. And in terms of the father's understanding, whatever the father understood that the deal was, there's a reason parents are given the assistance of counsel. So at all times he had counsel. At all times, he had somebody to help him navigate the system and help him understand how urgent these issues were. He's the one that did feel the urgency.
Counsel, could you address the issue of whether there was a stipulation that reunification efforts were adequate or reasonable? Would we be able to determine whether or not that stipulation was made by looking at the transcript, or how would we
Well, here,
determine that?
I don't think you need to, and here's why. He did stipulate to the number of services given,
Okay.
and he did stipulate to the treatment plan. And at every review, there was never a motion to say, let's amend this plan, let's change this plan. My client needs these kind of services and not those kind of services. So if, let's say, he didn't stipulate that these services were reasonable, this court can look at that list and can take judicial notice that there were no objections to what was in the treatment plan and say, yeah, the judge was in his discretion in saying this list of services adds up to it. We also have case law that says when you look at reasonable service efforts, you also look at the attitude of the parent in engaging with those services. And he engaged with services that had to do with mother. But the crucial services that he really needed to provide was to learn how to parent this very wounded child. He didn't do anything to learn how to do that in a way that the child needed.
So can you tell me how it works when you have a parent who's not in the state of Utah? Because normally those counseling services and things like that might be offered by, my understanding is, DCFS at no charge if the parent can't not afford them. Is that right? But how does it work when you've got a parent in another state?
Well, first of all, I think it's incumbent on the parent to parent the child, to come to where the child is.
Okay.
I think when a child's in the custody of the state, you already know that child's been traumatized by removal. You know that child has special needs. That you can't long-distance parent that child. Sometimes we have cases where the father or mother are incarcerated, then they can access services there. But in terms of services, once an ICPC is completed, then there's an ability for the parent to access services there, but this court still maintains jurisdiction. But I think if you look at what is one of the definitions of abandonment, and I know that's not the ground, but is, did you show the normal interest of a natural parent? And I think saying, well, I know my child's in care, but I'm cool staying here, that's okay. That is not the normal interest of a natural parent. And he did show an ability to be able to come out here, and he could have moved out here, and it would have been more difficult because of his poverty, that's true, but that is what this particular child really, really needed in his moment of
But
crisis.
but if the father had moved out here, is it correct that he would have been able to access those services free of charge here that he couldn't access in California?
That would be a part of the treatment plan. So I don't know
Okay.
if he would pay for it or not, but that's something his counsel certainly could have asked for.
I see.
And that's something that oftentimes the division, that you can line up such services
And
for free.
did you argue that his rights should be terminated because he did not move here from California?
I don't know if that was argued. I know that the therapist put on some really good, the therapist as well as the caseworker put on some really good evidence that he really could not progress more unless he was right here to learn how to do that. And the caseworker testified that she was very persuasive with him to come out here and to learn how to parent this child. So I mean, his disinterest was obvious. And I think the court was well within its discretion in finding that the father was disinterested. In terms of strictly necessary, under the Adoption Safe Family Act, if you do something, first of all, this child was less than 3. So under 62A 4A 205.9, It says if a child is under 3 years old and can't return home, the permanency goal shall be adoption. That's a firm statement from the legislature about the importance of adoption for young children. Also, under ASFA, even when a relative is going to adopt and you want to arrange for guardianship funds for the relative, you first have to rule out adoption, and you have to talk to the division is under an obligation to speak with the relative about adoption as a more permanent goal. So adoption is a rule out. So ask why not a more permanent option rather than why a lesser permanent option. So unless this court has more questions, I will leave it to my colleague. Thank you.
May it please the court, John Peterson on behalf of the state of Utah. I think I'd start with the question of the reasonable service issue. Mr. McGinnis, to his credit, did call me yesterday and informed me that he thought there was a clerical error in the court's final order. And my response to him, as my response to the court, is that if you believe there's an error in the court's order, it's incumbent upon you to point that error out to the court and allow the court the opportunity to correct the error. That's the essence of preservation. It also serves the benefit of pointing out that the court may want to make additional or more detailed findings on an area that didn't seem to be that important, given that the court believed that there was a stipulation. What Mr. McGinnis actually intended, I mean, I think when I looked through the record and the minute entries, I could see that maybe it's possible that's what he intended. It wasn't entirely clear to me from the record whether the judge realized that or not. Apparently, it doesn't seem like the judge did realize that. But I think in any event, even if this court were
I'm sorry, wait, it wasn't clear that the judge realized what?
that he maybe only intended to stipulate to some issues that the issues of proper and that the permanency hearing and the termination trial be combined, not necessarily that the division's efforts were reasonable. Somewhere in there, that his maybe stipulation went farther than he thought it was supposed to have gone. Seems that may be accurate, but I don't know. But I think what wasn't the judge didn't seem to realize, and that's really what's most important, is that the juvenile court judge should have been informed. But I think even if this court looked at the merits of the issue of services, the judge did make actually fairly still extensive findings. But what the division did do, and they, to the best of their ability, they tried. I mean, obviously, our caseworkers are not licensed to practice in California, so they have limitations there, and we don't have contracts with California providers. But they did try to at least give him lists of competent people he could address. They did offer to assist him with not transportation, but lodging. I believe food also was offered. So a substantial portion of his travel expenses. But I think what the record demonstrates is that he wasn't really very interested in interacting. I mean, you have a child who really, I think, you can't say this very often, but doesn't even really seem to know who he is. I mean, Skype visits obviously are not ideal, as Judge Appleby pointed out, but there is evidence that the child did react to other relatives and people that he seemed to like on Skype, and the father didn't seem to be one of those people. Also, the father's one visit didn't occur until October of 2018. He was given 90 minutes, and he cut it short. This is the only time he'd seen his child since 2017, and he didn't even stay there for his whole 90 minutes. The division offered to pay for a hotel so he could come back the next day and see the child again, and he declined, saying, I gotta get back, I got stuff to do. He just doesn't seem, unfortunately, like a person who's very interested in his child. So when counsel suggests that there's alternatives to termination to preserve that bond, I think the juvenile court was correct in believing what bond. I mean, the lack of father in this child's life is not going to affect this child one iota. This child came into the division's care extremely damaged. And I think, as Judge Hagan pointed out, there is evidence that that was not organic. That was something caused by his circumstances. Ms. Quinlan, who is an experienced therapist, a master's level psychologist with over 10 years of experience, diagnosed him with child neglect and possible physical abuse. And I mean, he behaved almost like he was on the autism spectrum. He didn't communicate well. He didn't play. He would do weird compulsive things like flip lights on and off. He hoarded food. I mean, he was a child with significant damage. And within a fairly short time of his foster parents and the school helper and Ms. Quinlan working with him, he got to the point where he actually started to seem like he could be a normal child again. And I think then he's placed also with family, which is, what the division strives to do in cases where we can. So there is some degree of continuity with relative.
Did the district court explore whether the foster parents would be open to a permanent guardianship arrangement as opposed to adoption?
I don't remember that was ever really addressed. I think there was no real discussion about whether they were open to that or not. I think the court's conclusion was like, why would I want to, maintain this? Because when there is no bond, I don't see the importance of trying to preserve something which doesn't exist over a family which has adopted him, brought him in, where he's stable, loved, doing very well. And mother either, because the mother had warrants out for arrest. So he was, pretty much. Neither of them has really spent any time with him since about 2017, aside from father's 60-minute visits and a few Skypes where father was fairly disengaged and would often just sit in the background behind mom, and that's really the child. And the child is now, I believe, 5. He was I think around just a little over 2 at the time of removal. A very young child. There's really not much there.
Can I drill down on the services issue again? Sorry to take you back to that,
That's
but
fine.
so he couldn't be offered services in Utah because he was in California. You tried to get California to provide those, is my understanding. They refused. So at that point, what are the father's choices? Are they move back to Utah to receive those services, pay for them out of his own pocket in California, and if he truly doesn't have the funds to do that, then what is expected? Should he have raised that, for instance, with the court, that he was wanted to but was unwilling to comply? Just walk me through how that works, please.
Well, part of it, I think as Ms. Pierce pointed out, it is incumbent if you don't ask, you don't necessarily get. So if it said something, but also part of the problem is there's certain kinds of parental services that are really most effective in the context of the parent and child being together. It's very hard, for you to be given the skills and to work on your relationships in separate places and not even in the same room. But I think if father had made a direct appeal to the juvenile court, I would ask that the division be ordered to provide such and such. It could have happened. I don't know if it would have necessarily helped his situation a lot. He has a fair history of not doing much. His psychological evaluation suggested that he's a person who really should be having personal therapy on a regular basis, and that's never happened. He did testify that he's now kind of got his psychotropic med situation going, so he's a little bit more stable that way.
But did he ever raise the issue to the district court and say the reason I cannot complete these requirements, this service plan, is because I can't afford it? Was that ever raised to the juvenile court?
I don't believe so. Certainly not in the context of developing the service plan or periodic reviews or asking for things that have not yet been provided.
So the state says we'll pay for your lodging and your meals. Are you saying he never said, but I can't afford to get there, I need a bus ticket too?
I don't believe he ever said that. And they asked him at his termination trial, was this the second time he came to Utah? And he was asked directly, said, was it a hardship for you to be here? And he said, no, not really.
But did that go to whether he could afford the gas? Or did that go to was this inconvenient? And well, no, it's not really inconvenient, but I can't afford it.
From the record, as it's composed, I don't recall anything record of father saying I can't even afford to pay for gas to drive to Utah. I don't think that. So that's. I don't think that was actually raised. I can't answer one way or the other what they. Oh, I do see I've used up my time. If you'd like me to finish any more, appreciate the court's time. Thank you.
Mr. Peterson. Mr. McGinnis.
Michael McGinnis on behalf of Mr. Keogh. Your Honor, first to address some of the things that were brought up, let's talk about the ability to move here. I asked Mr. Keogh this at trial. Mr. Keogh took years to get in Section 8 housing, years, in California. And if he left, he would have lost that housing. Number two, he spent years trying to get on state disability. If he'd have left the state of California, he would not have been able to get on the disability he was able to get on at the end. He'd been trying to do that for 3 years. So those are the factors of why he cannot move here. I think it's easy for us who have never experienced extreme poverty to judge him. That I think there's thousands and millions of people in this country that would have acted just like Mr. Keough and are in the same situation as Mr. Keough. that
What
have-
about leaving the 90-minute time with the child he hadn't seen in a couple of years?
Yes, Your Honor. Mr. Keough had to get a ride here from a friend who was driving through, and that's why he left early. So
Was that evidence submitted to the court?
I asked Mr.
At
Keough
the
that at
time.
trial, I believe. I think the court can look at the record. I think I asked him that, but that was his explanation to me.
Can you answer my question about whether he ever informed the court that he needed additional state resources in order to complete the requirements for reunification?
Yes, Your Honor. It wasn't addressed, actually, it was addressed at trial. He talked about not being able to afford the services until later on, until he got on disability. But it was also brought up when we had when the trial court terminated reunification services. I think the arguments that we made there were that he cannot afford to pay for the services. The only thing the state provided to him was a list of people in the state that he could go to. Mr. Keough got engaged in domestic violence counseling and substance abuse counseling, both of which the division said that was not sufficient. And that was in the first 4 or 5 months of the case. Then he got into treatment with Dr. Parvin. Dr. Parvin testified telephonically at the trial and talked about the treatment that he was doing with Mr. Keough, the domestic violence treatment, all the counseling, and that was required by the division.
What about parenting skills?
Dr. Parvin also addressed, she was, seemed like a really sharp doctor. She had experience in treating substance abuse and parenting. She was addressing that with Mr. Keough, and Mr. Keough was going regularly to see Dr. Parvin. And one factor I want to point out to the court is after unification services were terminated, meaning the division wasn't going to help him, Mr. Keough kept going. He didn't quit doing the services. He still went to Dr. Parvin, even though he was not getting any benefit from it from the court. I mean, there wasn't anybody saying you have to do that. And he continued to do that because he had the ability at that time to do it. And he was trying to show the court that he wanted to get his son. One last thing, I'm looking at my notes here, is that the state would not pay. The state would not pay for that for out-of-state. The caseworker made multiple requests for that. But there was no funds available for him to travel out here, and they would only pay for 2 days of lodging for the entire case. So I don't see how that would have made any difference at all in the outcome. But I'd ask this court to overturn the lower court's findings. I think they were not within the bounds of the law, and that's it, Your Honor. Thank you.
Thank you, counsel, for your arguments today. We will take this matter under advisement and render a written decision as soon as we